Viewers, welcome back to the show. Before the break, we're talking about road accidents and instances on the road. The interesting topic we've got tonight, and now, which leads us on to our subject of discussion, is this contentious issue about reducing the alcohol level at 0.02. What do you think, Rob?
Well, look, it's a really interesting idea that they've got here. They're basically suggesting that 0.05 is too high, the limit. People who are getting close to that alcohol limit are too inebriated to drive, and by reducing it to a lower level, then we can reduce the fatalities on the road. So that's the idea behind this plan.
Don, what do you think?
Well, the statistics show that they could reduce up to 10% of the road toll. And they've trialled it in Sweden. I think in Sweden they actually reduced it to 0.02, now it's permanent, where the stats from Sweden show that at least 10% reduced road tolls as a result of that change in the legal alcohol level when driving. So if that's the case and that's the stakes, I mean, I think it's worthwhile looking into, Tony.
Well, people I've spoken to think it's too low because what it means is that it creates too much anxiety, I guess. You know, what is it, one wine or possibly one mixed drink? I
think it's equivalent to one standard drink. Now, I think there will always be this type of topic or disagreement as to whether or not we should or shouldn't, and there'll be some, of course, anxiety out there. But I think it goes the same as smoking, Tony. When smoking was banned in all inside areas, everyone was been anxious about it, apprehensive about it, and then everyone's accepted it. So it's going to be part of our culture.
Don't forget also, there's a bigger issue here. You know, let's say for argument's sake, someone's been picked up 0.02 whatever, and they lose their licence. Creates a lot of issues in terms of transport to work and this and that. I'm not particularly sure that if someone having 2 drinks and losing their licence is what society really needs, and that's what people are saying to me. Rob?
Well, it's really, it seems to some to be a drastic measure, but I think it's just been pushed forward because of the high number of fatalities and the high number of serious injuries that have occurred on the road. People might be getting desperate just to try and find some way just to reduce these road tolls. And I mean, as we've always said, you can't put a price on human life. And if that's one of the things
if you can save one person,
it could make it worthwhile entirely.
But the sceptics are saying it's a cash grab again, Don.
Well, that's the other argument, Tony. It could be a cash grab because it won't take anyone long to get over the 0.02. Again, one standard drink. You have 2 standard drinks, you're over. So, look, there's always that side of the fence, if you like. But I'm with Robert on this one. I think if it does reduce 1 life, 2 lives, 3 lives, it is worthwhile looking into.
Look, the reality is if they bring it down to 0.02, you effectively cut out anyone's opportunity of going to a bar, sitting down with someone having a drink, because you have one, realistically, you're probably going for 2.
Yeah.
You know what I mean?
Part of
and
the
then
culture.
you're over the limit.
And look, Rob said it is a culture thing.
And I know the hoteliers and restaurants and all these people are really against it.
Yeah.
Obviously, they've got their own self-interest. But anyway, viewers, let's move on to the topic of transport accidents. There's a very interesting case of Transport Accident Commission and a state of viewer. Now, obviously, there's been a death in this case. Rob, what's the facts of this case?
The facts are somewhat complicated. It concerns Mr. Baines and Mr. Ewer, who are 2 very good friends who'd known each other for years. One evening they got together with some friends and they were just having a good time. They were at a friend's place. Mr. Ewer decided he wanted to go bowling, so he went to the bowling club with a couple of friends. Mr. Baines stayed behind and ultimately followed them to the bowling club. Decided he wanted to go to the pub, so he went to the pub with Mr. Ewer's partner, and so they were in separate venues for some significant period of time. And that's relevant because during that period of time, Mr. Ewer had a fair bit to drink at the bowling club. Now, at some point in the night, Mr. Baines needed to call Mr. Ewer to come to the pub to help change a tyre. From there, they went back to another friend's place, and then ultimately from there, they were going to go again to another friend's place. There was a lot of movement on that evening, and they spent a fair bit of time apart. But on that last trip, they never arrived at the place they were supposed to go to. The friends who were waiting for them went out looking for them, and they found them tragically on the road. The car had had an accident. The car had completely spun around. It was a ute, and both of the Mr. Baines and Mr. Ewer were ejected from the vehicle or were outside the vehicle on the road. Unfortunately, Mr. Ewer had passed away. He was deceased as a result of the accident, and Mr. Baines was very significantly injured.
And Don, this was a case by the Transport Accident Commission seeking indemnity against the interstate insurer.
That's right. The alleged driver, whoever it was, that was one of the contentious issue. Who was the driver? Was in a South Australian registered vehicle. So under the Transport Accident Act, the Transport Accident Commission, who's paid some benefits because it happened in Victoria, to the injured people can recover from the insurer. So this action was between the insurance companies, if you like. about who should be paying what.
Is it extraordinary? Okay, Mr. Yu is dead, but how irresponsible. He is absolutely blind. He knows his mate's got this predisposition of being blind himself. So he's given him the keys so he can drive them both. And sadly, the one that handed over the keys died.
Yeah.
It's just so irresponsible. But then the courts come back because they've got to determine the issue of who's driving and who's liable because of this monetary grab by one of the insurers.
Well,
okay.
The issue was who was the driver. Now, the evidence came out that the last person to see Mr. Ewer and Mr. Baines said that Mr. Ewer was driving, but then there was an allegation that they might have swapped. But that wasn't upheld in the court. And then the second issue was, well, even if Mr. Ewer was the driver, has Mr. Baines assumed the risk of getting in a car with someone who's drinking or had been drinking for some time? And then even if that's the case, there'll be no damages recoverable by Mr. Baines because he would assume the full risk, or if he's liable for contributory negligence. So that's in essence what the case was about.
Just on the points that Don raised, Rob, is it a complete defence that if you get in a car with someone that's blind drunk?
Under some limited circumstances it can be. If you are fully aware of the risk that you're getting into and you are fully aware of the relevant facts and you still assume the risk there, it can be a full defence. So you may be able to claim no damages at all. Now, fortunately, in this case, that wasn't made out. On the facts, as we discussed, Mr. Baines hadn't seen Mr. Ewer do a lot of his drinking. So while the court decided he would probably have been aware that there was some degree of drinking, they didn't feel that he was fully aware of just how inebriated Mr. Ewer was when he got in the car.
They were pretty good friends, Rob.
They were.
Bottom line, Don, he knew that he had a predisposition to getting blind drunk on more than one occasion.
Well, it brings us back to this culture thing. There was a big culture, social setting of drinking. There was obviously evidence that was submitted that suggested that often they used to go out when they're quite inebriated and do spotlighting and hunting and all those things. But the other thing too, which is interesting, Tony, in the case I referred to the fact of the TAC's campaigns regarding drink driving. People, residents of Victoria, are well aware of the TAC ads, so well aware of the drink driving ads about how dangerous it can be jumping in a car with a drink driver. So they referred to that when they were looking at the issue of VALENTI, which is voluntary assumption of risk and contributory negligence.
Can I say this? You know how we're talking about the .02? This is one case where if one of these two gentlemen had been in trouble with the law before for drink driving, I think a .02 scenario should apply to them because, you've been there before. We've got to go to a break. After the break, we're going to come back to the decision of the court in this particular case and look at some other cases. So stay tuned.